Welcome to Law and Nature, a program sponsored by EarthX. And today's program is going to be addressing international environmental issues. As those of you who work in the environmental field know, it's hard enough to try to navigate those issues here in the U.S. And when you add the complexity of language, culture, and different rules all over the world, you can imagine how much more difficult that is. And so our experts today are going to try to bring some clarity to those issues and discuss some of the ways that people can get ahead of any kind of problems. Our first speaker is Scott Fulton, who is the president of the Environmental Law Institute. And prior to that, Scott had many years in government. He was general counsel of the Environmental Protection Agency, and he has been fabulous in bringing the rule of law across the world and including training judges in other countries on environmental law basics, so that if somebody has some issue in another country, the judiciary is at least prepared on how to analyze and address those issues. Our second speaker is Tracy Hester, who is a professor of environmental law at the University of Houston, has worked so much on climate issues and other just cutting issues. And Tracy is going to talk about the really practical problems associated with liability in the U.S. for toxic tort and other environmental violations that occur in other countries. And then finally, Jim Bruen is going to be our final speaker, and he's going to be talking about the practical ways that companies can set up systems to anticipate and address environmental issues in other countries. Jim was president of the American College of Environmental Lawyers, recognized all over for his expertise in environmental problem solving. So, Scott, let's turn it over to you.
Thank you, Pam. Great to be here with EarthX today for this important conversation. I'm going to try to set a little context for us by talking about some of the broader trends that are influencing international environmental law and policy. And let's start with a couple of megatrends that may not have obvious environmental signatures, but are nonetheless to the environmental terrain. First, technology. I am at bottom a believer in technology as one of our primary hopes for the future. There can be a downside to rapid technological advancement, and a case in point is perhaps what's happening in the information and communication software space and the social media revolution. Very much in the news at the moment, driven by the recent Senate testimony of Frances Haugen, a former Facebook product manager turned whistleblower. The rather grim story emerging from Ms. Haugen and a growing number of other sources describes a platform that's been used to, among other things, sow cultural division and undermine democracy. We're told that Facebook's algorithms tend to promote and amplify sensational content, such as posts that feature rage, hate, or misinformation. And as we've learned, when fictions become conviction in the minds of people, trouble is sure to follow. And the storming of the United States Capitol on January 6th is a loud and visible case in point. But disinformation is playing a broader, more pernicious role. Conspiracy theories enabled by disinformation are elevating cynicism about government, about institutions, even about democracy itself, fomenting openness to autocratic or even fascist alternatives, and fueling nationalist and anti-international zeal. And of course, social media is but one mechanism through which such misinformation is flowing. So a big problem, but what does that have to do with the environment? Well, it's relevant to us because environmental solutions have always depended on societal consensus for action. Disinformation can confuse or cloud the public debate, impede consensus, and slow or prevent response. And we can see this at work in the context of climate change, a global problem requiring a global solution. where denial by some of the overwhelmingly predominant view of the science has made the world exceedingly slow to act on an issue with potentially existential implications for humanity and other living creatures. And we also see that the willingness to overlook the science is making it difficult to even respond to a pandemic in a coherent and effective way. So let's talk for a moment about the pandemic. Does this have an environmental dimension? I would say yes. At bottom, it does. The most likely explanation of the origins of COVID-19 remains that the disease is a spillover from animals to humans. Whether the specific cause of that spillover was a laboratory studying an animal-originated virus or a wet market selling wild animals almost doesn't matter. Scientists have been warning us for decades about the risks of species-jumping viruses and the sorts of conditions that can produce this kind of transfer. And we've had prior undeniable experience with this via SARS, MERS, and the like. A recent report by the UN Intergovernmental Science Policy Platform on Biodiversity and Ecosystem Services estimates that there are 1.7 million undiscovered viruses in animals, and that about half of those have the potential to migrate to human beings. And indeed, 60% of current infectious diseases are zoonotic in origin, and 70% of those come from wild animals. So the bottom line here is that stressed and unhealthy animals represent a public health threat to human beings, and destruction of animal habitat and migratory patterns contributes to animal stress and intensifies animal interaction with human beings. So this is a classic expression of the idea that failing to protect nature is failing to protect ourselves. Okay, let's move to a few trends with more clearly defined environmental signatures, starting with the biggest one of all, which is climate change. The issue is front and center at the time of our taping, as the world community is preparing to gather for the 26th Conference of the Parties, or COP, under the United Nations Framework Convention on Climate Change in Glasgow, Scotland. Several of us on this panel will be there to try to contribute to those discussions. My focus there will be what Pam has already mentioned, which is the importance of the judiciary in meeting climate objectives, and a project that we have underway to equip judges around the world with education on basic climate science so that they're prepared for the increasing number of climate-sensitive cases coming before them. Tracy will have more to say about the role of the courts in his part of the discussion today. Today's program will be broadcast after the COP, but I think we can safely forecast what the COP will yield. As a backdrop, recall that the 2015 Paris Climate Agreement had the goal of limiting global warming below 2 degrees Celsius and preferably to 1.5 degrees as compared to pre-industrial levels. Countries submitted so-called nationally determined contributions, or NDCs, to help achieve that goal. The Paris Agreement called for the updating of the NDCs every 5 years. So the most important to-dos for the upcoming COP will be discussing what was achieved from the last round of NDCs, with respect to which I think it's fair to say most of the world seriously underperformed, and then gathering up and tabulating the updated NDCs. Updating the NDCs is no trivial undertaking, as climate science has continued to evolve and inform what is needed. The Intergovernmental Panel on Climate Change, the science body created by the Framework Convention, issued its most recent report just this past September, and it is not encouraging. The report doubles down on the grave and potentially disastrous implications of a 2-degree increase and points to an accelerated rate of change, finding that the Earth is already on the doorstep of the 1.5 degree threshold, is already experiencing the consequences of a changing climate, and will likely reach 1.5 degrees by 2040, our mitigation efforts notwithstanding. So the goal of this COP will be to try to muster the big emissions cuts needed to help keep temperature from going past 1.5 degrees over the long haul. And that is a tall order, as it looks like we are more likely tracking to a 2-degree or higher increase, which would make for a world inhospitable to life as we know it. And not just inhospitable for us, but for all living creatures. And maybe a brief word on another trend line, what's happening with biodiversity, also greatly affected by climate change. Extinction of species is, of course, a natural process. But the rate of extinction that we're experiencing today is estimated to be between 1,000 and 10,000 times higher than the background or expected natural rate of extinction. And unlike the extinction events before the industrial age, the current extinction phenomenon is one for which a single species, ours, appears to be almost entirely responsible. And we're at risk of losing up to 1 million more species in coming decades if we don't somehow bend the curve on this. Does it matter to us as humans? And you bet it does. The variety of species and their habitats plays a vital role in ecosystem function and ecosystem services. And those include things like nutrient and water cycling, soil formation and retention, resistance against invasive species, pollination, local climate regulation, and pest and pollution control. So we're in a hard spot with biodiversity loss, and it's getting harder. You might wonder, why are we struggling so in meeting our biodiversity goals, and for that matter, meeting our climate goals? And that's because of the last alarming trend I will mention, which is inconsistency in or failure of government systems. A recent report that our institute did for the United Nations Environment Program, styled as Environmental Rule of Law, First Global Report, found major rule of law gaps in the natural resource arena, pointing to a few key and interrelated problems, such as weak and underfunded institutions, vacillating political will, ineffective enforcement, and corruption. A very big problem, and it's hard to muster the intensity of purpose and resources to fix such a problem. Recognizing that I'm painting a fairly discouraging picture, let me point to some possible rainbows on the horizon. While historically we've tended to look at environmental problems as government's problem to solve, government is thankfully no longer the only game in town. There is emerging a whole of society approach to these problems that is being greatly assisted by private sector leadership and some positive contributions by technology. Jim's going to talk some about private sector leadership initiatives, so I'll be brief on this. I just want to observe that the sustainability agenda has strongly taken hold in the business community, and the drivers for this are no longer signals from government, but rather demands by consumers, business customers, shareholders, financiers, insurers, and other risk managers. And because the levers that attach to these expectations are really about access to markets and access to capital, which are the life's blood of business, they are quite powerful. And when these initiatives endeavor to not only reduce the environmental footprint of a particular company, but also drive the behavior of that company's entire supply or value chain, they have the potential to reach literally around the world and can help compensate for uneven government performance. As an example of this, Apple, having reportedly already achieved carbon neutrality in its own operations, announced just this morning an initiative to achieve carbon neutrality in its supply chain, or at least a major portion of its supply chain, so-called Scope 3 emissions, by 2030. And this is not a one-off, but is reflective of the kinds of initiatives that are popping up all across the business world. So look for the private sector to be a major and important voice in Glasgow. The last trend that I will mention takes me back to where I started, which is technology. But this time I'm talking about emerging technologies that offer environmental promise, so the upside of technology. There's a lot that can be talked about here, and indeed we have an entire green tech initiative at ELI aimed at this, but let me just focus briefly on what may be the brightest light, which is enhanced sensing technology, from space to drones to ground level, that is increasingly giving us near real time and highly granular data about so many things, from natural resource exploitation to local air pollution. So for example, we now have the ability to monitor forests daily from satellites at a resolution of 16 feet. That means you can detect from space the removal of an individual tree and observe and apprehend illegal deforestation as it is unfolding. This growing sensing capacity promises to change everything, and for the better. Non-performance and illegal action will no longer need to go undetected. Add to this the growing capacity of artificial intelligence to digest, synthesize, and make sense of the large amounts of data that new technologies are generating. Add to that communication software that can move the data narratives quickly into the hands of those who can do something about them, and not just government, but big supply chain managers and other stakeholders. And then, well, you have something to feel hopeful about. So I'm going to wrap up there. As I think you can see, just as everything in the natural world is interconnected, so too are the major trends affecting the natural world. So back to you, Pam.
Okay, that was excellent. Really appreciated your very insightful remarks. So Tracy, we're now going to turn it over to you.
Thank you, Pam. As always, it's a great pleasure to be with my friends and colleagues on this panel and to be participating with EarthX. I'm going to be talking about a topic that's in between larger trends that Scott's identified and some of the specific actions done by private parties that Jim will describe. I'm going to be talking about the world of transnational liability. We all know the important role that courts play in determining rights and remedies and liabilities when environmental harm occurs. But we tend to think of that in two opposite ends of the spectrum. International law, where we might have a decision made by an international body, like the International Court of Justice or the International Arbitral Tribunal, or a national court or a state court, where it's done under that nation's laws by a court under the powers and jurisdiction of that nation. But the reality is, most of the major environmental issues we're wrestling with, most of the significant economic activity we do has international dimensions. It spills across borders. So as a result, we can't think in silos anymore. It's not a question where we try and answer who's liable and who isn't from the scope of one board. We're actually having multiple issues, multiple courts dealing with oftentimes different facets of the same issue, all under their own separate rules, and all of which can impact each other. So this field is transnational environmental liability. And essentially what happens when someone from abroad sues you at home, or alternatively, you end up being sued in a way where someone sues you abroad, but then they bring that judgment to the United States to be enforced. Both of those have different rules that apply to them that have significant impacts. So I'm going to be talking about, first of all, that direct liability, where someone comes to the United States and sues in a US court for liabilities and harms that were created in their home nations abroad. This sort of direct liability is possible. It is premised in the fact that there's nothing in our judicial system in the United States that bars foreign litigants from taking advantage of our rule of law and our ability to have courts breach justice if the courts have met certain fundamental jurisdictional requirements. Now, just a small note of clarification, I am not talking about two different small smaller issues that are important, but really talk about different things. We need to remember that when US citizens go abroad, oftentimes US law still governs them when they're acting abroad. So for example, if I'm a US citizen and I throw something over the edge of a boat into waters, the Ocean Dumping Act may apply to me as a US citizen, even if I'm on the high seas. That's a totally different set of issues. At the same time as well, I'm not going to be talking about cross-border spills, where someone emits something or dumps it and it crosses the border into the United States. That's also a separate set of issues about harm in the United States that then leads to the exercise of US law over the border. I'm talking about something different. Like, for example, an actor goes abroad, does something like mining or energy production or other type of land reformation as part of a larger construction project and causes harm abroad. Now, in this context, a direct lawsuit in the United States is possible if those foreign litigants come to the United States and essentially allege a claim, either a US law that applies to them abroad, or alternatively, they want to bring a lawsuit under tort or other issues that could apply to the United States actor. In that circumstance, the basis for jurisdiction would be what we would call either a federal question, if there's like a federal statute that gives the ability for recovery, or alternatively, it could be under what's called diversity jurisdiction, where the federal courts can hear a case if there is what they call diversity between the parties. They come from different states, they come from different nations, and that diversity gives the court, the federal court, the ability to hear the case. Now, normally, that opens the doors for a broad array of cases that can be heard, particularly between citizens of different states within the United States, but not so here. One of the reasons why the US courts have been a difficult forum for people who want to sue in the United States for harm that occurred in their home is because, number one, that diversity I just talked about only applies if there is a US citizen in the mix. If you have foreign litigants on the defense and foreign litigants as the plaintiffs, well, that sort of combination of parties is not diversity. It's not complete diversity, and the courts don't have jurisdiction. So automatically, that rules out probably a large swath of the kind of cases we might see filed in the United States. But number two, there's a gauntlet of procedural challenges that a litigant would have to get past if they wanted to bring a lawsuit in the United States for harms for a cause of action abroad. Things such as they have to show that there's jurisdiction that the court can exercise over the parties. That the court can only bring someone before them if they have contacts. And there's a constitutional minimum level of contacts they must have. They also have to show that the court is the logical place to bring the lawsuit. There's a doctrine called forum nonconvenience, which basically says if the law and the facts and the witnesses and the judicial system that can most appropriately hear a case is the one that's abroad, the federal court of the United States can decline to take the case and send it to the other court first. Oftentimes they may put conditions on that. They may require that the defendants take certain steps to assure that they are not playing the system. But the bottom line is that forum nonconvenience is a powerful barrier to these kinds of direct lawsuits I'm talking about. There are other doctrines as well, things such as the doctrine of comity, which is basic, not C-O-M-I-T-Y, which reflects respect for other judicial systems. There's a doctrine called active state, which says the judiciary is not going to second guess the actions of a state within its own borders under its own laws. If you put all those together, especially with some other doctrines such as political question doctrine, it is very difficult for foreign litigants to come to the United States and bring a significant environmental claim for actions that take place abroad. And as a result, we do have some of those claims that have been filed, but they have a rather torturous history. To give an example related to that, there was a lawsuit that was filed dealing with Costa Rican farm workers who allegedly were harmed by the use of certain types of chemicals to kill pests. They filed in the United States, and that lawsuit was originally challenged on the forum nonconvenience ground. When that challenge was denied, the state legislature in a court where it was filed passed a law tightening what the foreign non-convenience standard was. So you can see it's a very difficult task for someone to try and bring these cases in the United States. In addition, there is one small area that's worth noting in that there's a cottage industry of these lawsuits that is filed under one particular statute called the Alien Tort Claims Act. This is a long-standing, very short statute passed way back in 1789, which essentially says that aliens can sue in the United States under the law of nations. And that simple statement has led to lawsuits claiming that parties who violate international law abroad can be sued in the United States under the Alien Tort Claims Act because international law applies to their actions. Now, having said that, the Supreme Court has been busily whittling down those cases. The most recent case is one that involved Nestle that dealt with the use of child labor abroad. And the US Supreme Court, in an 8-1 decision just this summer, basically said that the Alien Tort Claims Act cannot be read to apply extraterritorially outside the United States because Congress didn't say so clearly. It leaves very little room for the possibility of future lawsuits. But stay tuned, there's still at least a little glimmer of possibility based on US corporations taking actions that have a significant nexus to things happening in the United States. So those are direct actions. The other one are what I'd call the indirect actions, where instead of packing their lawsuits and coming to the United States and suing a US court, instead, if someone is hurt abroad, they sue in their home courts. They get a judgment, and then they bring that judgment to the United States to collect. Now, the most important thing to keep in mind here is that courts are usually loath to try and retry cases that have already been decided. So as a result, it's not a question of the US court retrying the case. They basically just check whether that foreign judgment meets minimum standards of fair play and due process. What are those minimal standards? Well, basically, as a matter of what we call federal common law, this is not written into a treaty or into a statute in the United States, the court's going to look for certain things that we expect to see from a fair judgment, such that the judicial system provides an impartial tribunal, that there is personal jurisdiction, that was fair to ask the person to appear before that court because they had some contacts with it, that there's some sort of notice that was given and there was no fraud that infected the judgment. Now, if you meet those standards, the court in the United States doesn't unpack it and try and figure out whether or not they would agree with it. They simply enforce it. Now, given that standard, you would think that it would be attractive for foreign litigants to sue abroad and then enforce the United States, particularly if there's no assets abroad and they have to come here because that's where the money is. Well, one example shows how fraught this process can be. There was a lawsuit that was brought by indigenous peoples in Ecuador against Chevron as the successor to Texaco. They alleged that oil and gas production in the Amazon with the Ecuadorian government's participation in the 1950s caused contamination that was still hurting them today. And after suing in the United States, those direct actions I talked about, they got kicked out for foreign nonconvenience and were told to go back to Ecuador, which they did. And in the classic case of a Pyrrhic victory, the Ecuadorian lawsuit resulted in a judgment that was ultimately pegged to be at about $8.65 billion. So the real story begins after that. Just like Eva Perón's body, it's all sorts of peregrinations and twists and turns after the actual judgment was made. In this situation, the judgment was attacked in the United States when it was brought before the Southern District of New York, and it was found to be infected by fraud. And it was actually a RICO lawsuit declaring it to be essentially an illegal action. And the court enjoined the enforcement of that judgment in the United States. Right now, the lawyer who brought that claim is, as we speak, reporting to be serving a sentence for contempt, civil contempt, for failing to provide information to the court as to how that judgment was obtained. That has led to a constellation of other lawsuits in Canada and Brazil and Argentina and even Grenada, claiming that there was assets that could be used to satisfy the Ecuadorian judgment, and all of those actions so far have been rejected by the courts. So this indirect route, that even if it results in a pretty sizable judgment, doesn't guarantee you actually can collect on it despite this reduced standard. So with that all in mind, what's next? The biggest issue on the horizon right now is climate litigation. There are climate tort lawsuits filed in numerous national court systems all over the world. And there is a very high likelihood that one of them will ultimately someday result in a judgment that will be attempted to be collected in the United States. When that day comes, all these standards we've been talking about will be applied and magnified. And we can expect to see an enormous battle over the enforcement of that kind of climate tort foreign judgment. A couple of predictions. It will be hard for Congress not to get involved if there is a multi-billion-dollar judgment dealing with climate liability. And Congress has already gotten involved in some other types of cases. For example, we have a federal statute that limits the ability to bring defamation judgment enforcements in the United States unless they meet our standards. It wouldn't surprise me to see that there'd be some congressional legislative intervention to make sure that the judgments collected abroad meet standards we would expect to see in the United States beyond just the simple ones I've outlined earlier. The other possibility is that we might see attempts to have preemption brought into play. Congress can essentially bar the enforcement of these kinds of claims. In that circumstance, target it with legislation. In that circumstance, we can expect that Congress might actually just directly foreclose these kinds of lawsuit judgment enforcement actions in the United States. But I think really the big picture at the end of the day is there will need to be a real discussion about whether or not this type of quilt of judgments and collections results in the set of incentives and policy that we need to try and move the world toward the direction we have to for climate change response. Frankly, right now, there's a possibility of it being fairly uncoordinated and mixed signals. And we probably need to have some sort of discussion about how to harmonize all these issues in a more systematic way to achieve a common goal. So with that in mind, hopefully that sets the framing for Jim to talk about what corporations are doing while all this transnational litigation is swirling around them.
Thanks so much, Tracy. You've once again confirmed why I believe you are the leading authority on this subject, and you did a great job of making the complicated simple. Okay, Jim, you're going to take it on home as our last speaker.
Hello. In the next segment of our program, we're going to talk about problem solving. And in particular, I want to give you a general overview in which I describe the creation, operation, and continuous improvement of an important approach to reducing multinational environmental, health, and safety liabilities. This approach has been used by Ford, Amazon, Walmart, Apple, and a number of household names. In my environmental practice for the last 25 years of my practice, I have been Global Product Stewardship Counsel to a number of household names in the apparel industry and the consumer products industry. And I want to tell you, based on that experience, how the companies in those industries solve one of the major problems of multinational companies. And that's how to produce a single form of each project that is lawfully sold in each one of the international markets it deals with. There are 192 countries in the world, and many of my clients sold or manufactured projects in over 100 of those countries. So they needed a product standard that would meet the legal requirements, the environmental, health, safety, and corporate responsibility requirements and desires of the company for each of the markets in which it's sold. I'm going to talk to you today about the system that Ford, Apple, Walmart, Amazon, Levi Strauss, and others use, which is based upon a set of specifications. The specifications themselves are called the restricted substance list. The list is not the management system, but it's a key part of the management system. So I'm going to tell you in the time I have allotted to me today what the system is, who uses it, how it's enforced, and then I'll show you examples of what the restricted substance list looks like. Now, with respect to the specifications that we refer to as the restricted substance list, it is really initially a list built on the bans or limitations of certain chemicals which are used either in raw materials, in the manufacturing process, or in the distribution of those products. And what we're looking for there in constructing a restricted substance list is to find the most restrictive requirements in any of the markets in which the product sold by that company is sold. And then we turn to the industrial hygienists and we find whether or not those requirements are sufficient to protect raw material workers, manufacturing workers, and end product users. If the requirements are not sufficient, we lower the levels of chemicals and other substances permitted in raw materials and in the finished product. If we need to improve end user safety, we again lower the limits and ban these substances if necessary. And then we can reverse the goals we set for ourselves in air emissions, water emissions, and solid waste disposal, so that if these bans and limits that are in our draft or substance list does not meet those goals, we again lower the restrictions and limits. Well, I say raise restrictions, make the contents of the chemicals lower in each product. And then finally, these restricted substance lists are used to standardize product labeling and to enforce recycling of products, which is particularly important now with extended product responsibility laws being passed in Oregon, Maine, and being considered now in 7 other states in the United States. These responsibility laws will be a model for international requirements on product distribution. And finally, the restrictions in our draft restricted substance list can be modified to reflect the corporate responsibility goals of our clients. One such goal is mentioned by Scott today. Apple has set a carbon emission reduction goal for 2030. That's the type of thing that can be put in the restricted substance list. Another example is when Theo Coburn wrote a book in 1996 called Our Stolen Future. That book was hailed as the most important environmental book written since Rachel Carson wrote Our Silent Spring. And in this book, Theo Coburn and her co-authors hypothesized that a number of chemicals were endocrine disruptors, and that in fact, the men alive in 1996 may be the last males able to father children on this planet, which led, by the way, the French press to say that may be true, but that won't apply to French men. The RSL is enforced through a number of mechanisms, and this is where the management system comes into play. It's enforced through rigorous education by the brand name involved of its raw material suppliers, of its manufacturing facilities, and of the public generally as to what is being restricted and eliminated in the restricted substance list. These restrictions are then enforced with contracts which have penalties in them with raw material suppliers and manufacturing facilities, so that you can return a lot if it doesn't meet the specification, or you can cancel a relationship with the raw material supplier if in fact that supplier does not adhere to the restrictions in the list. Then of course you don't trust those contracts entirely. There are surprise audits of all of the raw material suppliers and manufacturing facilities that supply materials to your brand. And beyond that, there is testing. The suppliers are required to test their products extensively for compliance to the testing. And then the manufacturer and distributors test the products as well for compliance. And here's the key to any testing regime. And I say this based on a quarter-century experience in this field. Tests are meaningless unless the testing standard is specified and the testing lab is required. A specific laboratory is required for evaluation purposes. If different test methods are used, different laboratories are used, the test results really are basically meaningless. And then the restricted substance list in all of these companies is evaluated according to something called the continuous improvement loop. The continuous improvement loop means that you plan a management system, you execute it by laying it out in the field, you then evaluate it based on your audits and tests, and then you revise the plan. And then you repeat the same loop again and again, so that the system of managing restricted substances and achieving other environmental health and safety goals is continuously improved. Let me turn to slide 2 of my presentation and show you a list of the major companies that can easily be found in an online search for restricted substance list to show you who's following this management regime. And they include, in slide 2, Apple, Amazon, Walmart, IKEA, Hewlett-Packard, Ford, Nike, Adidas, Lenovo. You get the picture. This is a system which is proven to be effective over the years and which works because it is a management system that is enforced the way I have described. And let me show you a couple of examples of what a restricted substance list looks like. Let's look at slide 3. This is a list suggested by the Industry Association for Footwear and Apparel, the American Apparel and Footwear Association, as of 2021. As you can see, with respect to chemical substances, which is only one of the types of things, again, regulated in this management system, those substances are identified by caste system, so that no matter what market you're in, everyone knows specifically which substance you're referring to, chemical name, whether the substance is prohibited or limited in either raw materials, in the manufacturing process, or in the end user process, what the country is that imposes the greatest restriction in the world, what the test method is, and then I would add what the laboratory for the test should be. And then it mentions other countries which regulate the substance. Presumably those countries have less severe restrictions on the use of the substance. And then let me show you one final example of a restricted substance list, which really illustrates well, I think, what I'm trying to drive at in terms of the breadth of this management system. And that's slide 4. Slide 4 is a typical restricted substance list used for manufacturing companies. And in this, if you look across the top at lead, for example, it will show you again the CAS number, the chemical, the threshold limit, then what those limits apply to. In other words, a company may produce different products for which the limit or ban may be different. And this system allows for that difference. It then gives examples, and then for each of the various limits applying to each specific process, it shows you the most restrictive regulation in the world for that. Look down 5 lines to the restriction on N-hexane and look to the far right for references, and you will see that the restriction there is company policy. Now, we found this type of policy to be followed in restricted substance lists. For example, after Theo Coburn's book in 1996, bisphenol A and nonylphenol were substances that were not highly regulated, but bisphenol A in particular was thought to be an endocrine disruptor. So a number of companies added bisphenol A to their restricted substance lists, even though it was not regulated, because that was the responsible thing to do. So this is the approach that I would suggest. I want you to take a look, if you would, at other restricted substance lists, which can be found in a Google search for that term. And you will see that there are many different variations to this approach. The approach is widely applied to not only meet legal restrictions, but with respect to safety, worker safety, and end user safety, but they can be used additionally to meet environmental requirements for water, air emissions, and they can be used additionally to meet corporate goals for social responsibility. And with that, Pam, I turn the program back to you.
Thanks, Jim. That was terrific and very informative. And now, if you're ready, we're going to have some questions. We're not able to tie in an audience, so you're going to have to rely on my questions. One of the things that I wanted to pose really to all three of you, I was hired years ago by a multinational company to summarize environmental laws in 17 Latin American countries. And one of the things that I discovered was that, contrary to popular belief, the U.S. doesn't have the most rigorous of all the environmental statutes in the world, and that in fact a number of those countries had environmental laws and regulations that were tougher than ours in certain areas. So my question to you all is there any country in particular outside the U.S. that you think has exemplary environmental laws? Because again, some countries, as you know, even have environmental protection embedded in their constitutions, which we don't. But just in your experience and your world travels, is there some country that you think, you know, they actually have some ideas that we should incorporate?
Pam, let me start with answering that question if I can. What we do to find out what the laws are for chemical content, for example, is to hire an international chemical testing lab. They track those. And for non-chemical requirements, we hire a lab like Underwriters Laboratory or Huntington Laboratory, which will track those comments. Certainly Switzerland and Germany and the United States, particularly California, have among the most strict requirements in the world, but there are lots of traps here. For example, in the environmental safety, in the health and safety field, the EU requires 42 millimeters between the two prongs of their plugs. Some Asian countries require 40 millimeters, and it is a crime to sell a product in Asia, in some countries, that has European plugs on it, even though they look identical to the casual observer. So there are both countries that are very safe, like Germany, Switzerland, California as a state, and then other international laws that are dangerous, that don't appear so on their face, like the plug law relating to safety.
Pam, I might also offer a thought too, but then get out of Scott's way, because I'm sure he has a much more thoughtful response. I am not really excited about trying to identify other nations that have environmental laws that might be characterized as better than the United States, but there are certainly other nations that have taken more creative and aggressive approaches to environmental law. And it's interesting to watch what's happening in Colombia and New Zealand and other nations which have actually tried to invest aspects of the environment with actual personhood and special rights. The Philippines also has additional ways to vindicate environmental rights outside of strictly the judicial process, but still involves a public forum with an opportunity to produce records that identify needs for additional environmental protection. The other thing I'll say briefly is that a lot of nations have great environmental laws in the books, but their enforcement is much more problematic. And some of the most interesting developments have actually been efforts to ratchet up enforcement apart from the environmental laws underlying it. So for example, the new US-Mexico-Canada agreement, the replacement for NAFTA, actually has strengthened the process to review enforcement of environmental laws among the three nations, and the ability to challenge the failure to enforce a law that's in their books that might be an unfair trade advantage. That is a nice way to basically not try and ratchet up the laws as much as just to make sure they actually mean something. And that's a great way to go at it.
Right. That's a good point, because in my research, I did find that there were some countries that had wonderful laws, but they weren't enforced. And so you have to have both. Scott, did you have anything you wanted to add?
Just a couple of thoughts. I do think that last point is fundamentally important, and just to brag on the United States a bit, I think when you look at the coverage of environmental topics across all of the statutes in the United States, and you add on to that the commitment to rule of law that has been reflected over time, I don't think there's any question that historically the United States has been the standard bearer when it comes to environmental protection and the laws that guarantee that. I would point some focus in a slightly different direction than what we've described so far, which is China. It's worth watching what's happening in China, partly because the Chinese are deeply solicitous of the experience to date in the environmental protection space. They've spent a lot of time learning from the United States example, but they also have been visiting with the countries of Europe and some of the others that we've mentioned here to try to distill from the world experience the best practices and regulatory approaches. And what we're seeing unfold in China in terms of the laws that they're developing are reflective of that. I'll also mention that, to their credit, the Chinese government is also solicitous of the experience of high-performing multinational companies in terms of what works well in their experience, what a well-designed environmental protection program looks like that is also manageable on the regulated side of the equation. So we've got a project called the China International Business Dialogue on Environmental Governance that creates regular dialogue opportunities between high-performing multinationals and Chinese regulators. And to their credit, again, the government of China takes those thoughts and ideas on board in the construction of their approach. So what emerges there, I think, will be important for many years to come.
Thanks. One more question. There's a lot of confusion and a lot of criticism about the use of the terms carbon neutrality, net zero, ESG, and among the general public, there is a sort of a desire for one standard or criterion for good performance on the climate side. Or do you find that those terms are used loosely and that a lot of people don't really know exactly what it means when a company says they're going carbon neutral?
Yeah, I think for the general public, there is some confusion around the use of these terms. And I think within particular companies, it's reasonably well understood what they're aiming for and how they're trying to get to what they're aiming for. It remains to be seen whether ESG or environment, social, and governance as a new framing for sustainability will allow for better currency with the public. I'm not sure. I think in some ways, the notion of sustainability and avoiding the irretrievable commitment of resources is kind of an elegant notion that is easily confused. But it could be that out of the COP, we'll get some useful new terminology that will help us understand this kind of crosswalk between carbon neutrality and net zero and that kind of terminology.
This isn't the first time we've had to wrestle with the ambiguity of terms that consumers need signaling on. Certainly, the long-running fight over what constitutes organic produce and food is not a promising signal as to whether we'll have clarity anytime soon as to what net zero or neutrality means. Even if the government does decide to try and set some standards to define what those terms mean with some regulatory bite behind them.
And Pam, let me add one point, which is from the consumer product stewardship perspective. I've always advised my clients to be very careful using terms like that. There are several famous cases, including one by a famous fruit company, that's a household name, where they said that all of their products were grown on environmentally responsible plantations in Honduras. And an environmental activist group went down there, filmed the operations, which looked like a moonscape, and then sued the company for consumer fraud. So the ambiguity here actually is something that presents problems for product manufacturers and distributors if they simply blithely adopt that term and tell consumers that's something they adhere to. They have to be careful that it's true.
Well, as you know, there are a lot of cases being brought alleging greenwashing, which is another term that has suddenly become a sort of a rogue's fashionable term. So, well, thank you very much for your participation and your thoughts and your insights and helping us try to figure out how to navigate the difficult waters of international environmental law.